Hey everybody, how y'all doing tonight? Good evening. I'm coming to you guys because there's some movement in the Idaho 4 case, and I have to address some things that's going on. There's a lot of things going on. There's some things that I need to touch on, and it's going to be uh, a lot of different topics tonight. So forgive me if it kind of comes across that I'm switching subjects, but it's a lot of things that we need to cover. And I'm going to move from one topic to the next because there's a lot of different topics. Um, I'm not sure if everybody is aware, but the judge, he has set up a hearing that's scheduled for Friday, September 22nd. And this hearing is going to be on the defendant's motion to dismiss. And the motion to dismiss is based on 4 different issues. I'm going to read it to you, but it basically is covering the fact that the defense feels that they are not getting the evidence from the prosecutor. So they're alleging that the prosecutor is not providing that evidence, and they're calling it exculpatory evidence. And they're saying that the prosecutor has pretty much the way they've handled the evidence, that they feel like it's prosecutorial misconduct. Another big issue is they're bringing up the grand jury again, and they feel that it's biased. They feel that the evidence is not adequate and sufficient to proceed in this trial. And they also feel that some of the evidence is not admissible. So I'm going to read what was issued in the case and what the judge signed. But I want to just talk about a few things first. So we have some legal terms, of course, we're going to go over, and there's going to be some subject matter that we're going to talk about tonight. And some things that I think we need to highlight again, because this motion, this is something that we've been talking about for several months, but a lot of the evidence that's been discussed, the motions that have been filed by the defense, and what's coming out pretty much on a daily basis, some leakage in the case, and also from reading some of the motions that have been filed, we can assess a few things. And the title of my case subject for today is kind of a lot of different things, but there have been a lot of changes from what initially was stated in the case. And this is why I went back to the beginning. About approximately a month ago, I sat down and I had a video for at least 2 hours. And I went back to the beginning of when the first few days happened when Kohberger was arrested. I talked about his background. I talked about things that law enforcement said. This is going to be like a fast forward almost a year later, right? We're about 10 months fast forwarding, and there's been a lot of changes in the case, major changes. And I want to talk about those changes because they all relate to the motion to dismiss. Major changes that cannot be overlooked, changes that you typically do not see in a criminal case. For example, if the time of death is approximated and set, you typically do not have a change in that time of death because all of the experts and the coroner or the medical examiner or the pathologist that set that time of death, they made expert judgment from the known case facts, whether it be from the autopsy, from the investigators providing them details. They have come to a conclusion, for example, that this is the set time of death, some type of approximate time. If you later come and you change it, and you change it substantially, an hour, 2 hours, or whatever, that is going to affect how people view the investigation, because they're going to be looking at, well, how did you make this initial determination? What was that based off of? And how could that be so far from what you changed to? There have been so many changes in this particular case. I have a great concern that, and this is not particularly about Bryan Kohberger as a suspect, but my concern is when there are so many changes, when law enforcement is saying one thing and then they change what they say. If the coroner is providing certain specific details, but then those details are not accurate, we cannot blindly trust what is being said, because we can say there have been changes, there have been discrepancies, there have been details, important details that are not accurate, that have been changed, that have been inconsistent. And what I'm finding when I look back, there has been a pattern. I am picking up, I am seeing, I am finding a pattern. And it's not just me, it's other people that's looking at this case. And it's not to come down on the prosecutor, because really the prosecutor is relying on evidence, the investigators, the interviews, all of the information that's obtained. They're relying on that information, those details, those records, those documents, those videos, those interviews, those tips. They're reviewing all of that information, gathering it, putting it together, and they're presenting a case that supports why a person should be charged with a crime, right? So initially, on the onset, you cannot really go hard on the prosecutor, because initially when they receive evidence is based on what was provided to them from law enforcement. So that's police interviews, that's testimony, that's interviews with different people, that's gathering of evidence, that's evidence returning back from the lab, possibly identifying a suspect, right? Video, witness testimony, just different ways to gather information and build a case. So initially, no, you cannot pretty much get upset with the prosecutor. They're going off what is given to them. And they may even feel that after they focus on a potential suspect, that maybe more evidence will come, because you may interview that suspect. You may obtain a search warrant and search their home. You may be looking for something specific, DNA, maybe some clothing, maybe jewelry, just whatever, right? So initially, no. But at this point, we're no longer in the beginning phases of investigating the murders of these 4 students. We're 10 months in. So the prosecution, they have a duty. They have many, many requirements in the discovery phase. When they have put their arrest out, they did not have a preliminary. They went through the grand jury indictment process. They were able to get an indictment for Bryan Kohberger. So now we're at the point where there's a discovery phase, where there's collecting of evidence, reviewing of evidence, testing evidence, getting interviews, sitting down with witnesses, gathering your experts to review the evidence, and then If that evidence is considered to be important, that's going to be used and presented, you have to share that with the defense. This is the typical discovery phase. This is not what's happening in this case. For many, many months, there have been multiple motions for specific evidence in the case. This is concerning to me because why are you not sharing the evidence? Why is the evidence having to be obtained through various motions? Even if the prosecution says, for example, they are not going to use DNA evidence, that does not preclude the defense from receiving that evidence, even if the prosecution is saying, we're not going to use that at trial. The defense still can request that evidence. For example, in the Bryan Kohberger case, there was some other DNA samples that the defense requested multiple times. This is an issue that's ongoing. They want those samples, they want to test them, they want to try to figure out who does DNA belong to. In this case, they're saying that they're not going to use Bryan Kohberger's DNA and how they got it, and they're not going to put any of that in the actual trial. That still does not stop the defense for asking for that evidence. How did you obtain it? When did you obtain it? When was it processed? Who processed it? How was the family tree built? What did you base this information off? What data did you collect? Did you go and collect DNA samples? What did you test it to? So many questions. So today I'm here because I want to prepare us for the Friday hearing, even though the hearing is closed. So it will not be open to the public. There will be no witnesses to hear what the testimony is and what's being stated in court. Now, some people may feel that, oh, this is unfair, or why isn't the hearing open to the public? These hearings should be open to the public. The reason I believe the defense is asking for the hearing to be closed, it is to protect the integrity of the case information, the statements that will be on the record, possible evidence that will be introduced, that will be discussed. The judge pretty much, he will be basing his decision off of what occurs and whatever the case law is. But some of this evidence potentially, some of the statements potentially, some of the potential witnesses, this is not for everyone to see. It may be appropriate for the judge to see, hear, review, and consider, but not for the public, because what if some of this testimony, potential evidence, potential witnesses will not even be allowed if there's a trial? So you don't want to have all of this potential information, records, documents, testimony, video, witnesses. You don't want that out for the public to review, to consider, to assess, and even a potential jury pool. You don't want to taint what they may not even get to see, hear, review, or consider if it goes to trial, right? So that is why I believe the hearing is a closed hearing. It's also to protect Bryan Kohberger. The judge has the responsibility to protect Bryan Kohberger's rights as well. He has different rights, and we're going to talk about them. And it's partly his responsibility to ensure that his rights are upheld and protected in this criminal proceeding. So let's start with some of those legal terms that I said we're going to discuss. Let's do that now. So if you go to the Hidden Horror Facebook page, as I always say, I recommend that you follow along, that you read along, or maybe read it later, look at it later, or watch this video a second time and go over the information, because I believe it's very, very helpful. And I think it's a great way to learn criminal law and also follow what's happening in the case. This is currently happening in the case right now. So let's talk about what are some of Bryan Kohberger or criminal defendants' constitutional rights. So I'm going to read directly from the Facebook page for Hidden Horror. Criminal defendants have several constitutional rights. Perhaps the most essential protection is the requirement that the prosecution prove guilt beyond a reasonable doubt. So that is the standard. Beyond, past a reasonable doubt. That is the standard in this case, okay? But defendants have other rights too, and these are some of them, okay? They have a right to remain silent. So that means that they do not have to testify. They don't have to put on any witnesses. They don't have to say anything. Don't have to give their side. They have a right to remain silent. It's the prosecutor's responsibility to put on their case and prove their guilt beyond a reasonable doubt. If the defendant chooses not to say anything and remain silent, that is okay, and that is not inherent of guilt, okay? They have a right to confront any witnesses. That means that when the prosecution puts a witness on, the defense will have the ability to cross-examine them, to question that witness, really to try to figure out if they're being truthful, if they're being accurate, if they're being detailed in what's happening, if they're leaving it out, okay? So you want to remember that. Any witnesses, they can be cross-examined by the defense. They call it confronting the witness. They have a right to a public trial. They have a right for people to come in and hear, see what is going on with them. That helps everybody make sure that we're adhering to all of our responsibilities. So the sharing of as evidence, the getting a witness list, knowing who's going to be on the witness list, making sure that your attorney, your defense attorney is prepared, okay, for trial. They have a right to a jury trial, so they don't have to select that the judge is going to determine their innocence or guilt. They can pick to have a jury trial, and a jury trial is considered to be more their peers, their people from the community, people that will relate and understand in a layman's way what is going on, okay? And they can make the determination of guilt or innocence, not the judge. They have a right to a speedy trial, right? So we're hearing all of this information about what's happening in Bryan Kohberger's case, how he has a right to a speedy trial, how that there's been a delay allegedly on the behalf of the prosecutor by not providing evidence, especially exculpatory evidence, where the defense will have the time and the ability to review that evidence, right? Try to refute that evidence. Get evidence reviewed by expert, send that evidence to a lab, right? So all of that is affecting when this case can go to trial. If there's enough time for that evidence to return, for information to return, results be returned, and that his defense team will be prepared and equipped to handle the trial as it goes forward. Now, in this case, Bryan Kohberger decided to waives right to a speedy trial, which was scheduled to start October 2nd, 2023, because his attorney, his defense team probably did not feel prepared to go to trial because they're still waiting on a significant amount of evidence. Some of that evidence may be considered exculpatory evidence. And exculpatory evidence is evidence that would tend to show or demonstrate that the defendant is not guilty, okay? So the next thing they have a right to do is to be represented by an attorney. So some people, when they are not able to hire their own attorney, they can be represented by a public defender, okay? So they have a right to go into court with some legal representation. They have a right to receive adequate representation, not just any attorney. So in this instance, because of the charges and because of the death penalty case, they're going to make sure that he has an adequate defense team, and it may include one or more attorneys that can actually go to trial, be prepared, have experience in fighting cases where the death penalty is going to be an option. And in this case, they are seeking the death penalty if Mr. Kohberger is convicted. They also have a right to not be charged with the same crime twice. That is referred to as double jeopardy. And let me give you the exact definition of double jeopardy. Double jeopardy is a part of the Fifth Amendment. It's a provision that states that no one shall be tried twice, put in jeopardy of their life or limb. Okay, they cannot be tried twice for the same crime. If they are found not guilty, you cannot later obtain additional information, maybe different information, witnesses, and then charge them again with the same crime. No, you cannot do that. You only have one shot, one chance. So when you arrest a potential suspect, you have to have that case ready. You cannot just arrest people and hope that if you can get them convicted the first time, oh, I couldn't get you convicted the first time, I'll just try again later. No, it doesn't work like that in the United States. You only get one shot. So when you someone, you want to be very careful that you're ensuring that your evidence, your witnesses, the testimony, the video, the DNA, everybody that's on board to represent the prosecution and go on that stand is prepared, is professional, is honest, is willing to go on the stand, because you only have one shot. You can't change your mind later and say, well, we're not going to do it now. No, that's not how things work. Okay. So those were some of Mr. Kohberger and any criminal defendants. Those were some of their constitutional rights. And those rights, they have to be upheld. And the judge has the responsibility to ensure that Mr. Kohberger or any criminal defendant has their rights upheld, protected, okay? So that's one thing I wanted to talk about. I also want to talk a little bit, there's a lot to go over, but I want to read to you the actual order that the judge entered. So let me switch devices. I'm going to pull the order from this other device. And I apologize that it's not very clear. So this is how the order reads. The court having before it the stipulated motion for closed hearing on defendant's motion to dismiss indictment and good cause appearing, now therefore it is hereby ordered that the hearing on the defendant's motion to dismiss indictment on grounds of 1, a biased grand jury, 2, inadmissible evidence, 3, lack of sufficient evidence, and 4, prosecutorial conduct in withholding exculpatory evidence shall be a closed hearing, okay? And that hearing is scheduled for September 22nd. Okay, now let's talk about this, right? Let's break down these 4 parts of what the defense is alleging. Let's talk a little bit about the 4 parts. The first part is the biased grand jury. Okay, so if you look back, and I did not cover what was happening when there was different motions on the biased grand jury and what happened in the grand jury indictment. I just talked to you about what a grand jury indictment was, because in all honesty, Kohberger believed that there was going to be a preliminary hearing. So his defense had prepared for months to go to the preliminary hearing and present their evidence and be prepared to cross-examine any witnesses that the prosecutor put on. But from out of nowhere, the prosecutor disclosed that they had already had a grand jury indictment of Bryan Kohberger. The grand jury indictment, as I said before, I have a whole video on the grand jury indictment, but I'll give you a short version. You can present the case to a grand jury. A grand jury is a one-sided act where only the prosecutor is going to present the evidence, any witnesses, any video, any testimony, anybody that they feel is going to demonstrate why the defendant is the potential suspect. Now, this is a secret hearing, so no one knows that this is going on. The defense will not have any knowledge. They will not be a part of any of that hearing at all. They're not going to be aware that the hearing is going on. They will not hear or receive any evidence that was presented in the hearing. The only thing they will know is that the prosecutor received an indictment through the grand jury process. And that's what happened in this case. They were prepared, the defense was preparing to go to a preliminary hearing where both the prosecutor and the defense would put on almost like a mini case. And then a determination would be made by the judge if there was enough evidence to bind Bryan Kohberger over for a trial. But again, that is not what happened. The prosecutor decided at some point to present this case to a grand jury, and Bryan Kohberger was indicted by the grand jury. And if you want more details on that, please check out that video. It's about maybe 4 to 6 weeks ago. You can check that out and review that if you're interested in that process, okay? But we're going to move forward and just say that what the defense is alleging in this motion to dismiss the indictment, they're alleging that parts of what happened in that grand jury indictment, there was some bias. Now, some of the things that they brought up in their commentary in the motion, they felt that some of the questions were not properly checked. They were very concerned that possibly someone was not able to speak English, those type of things. So they brought those issues up, and they're bringing them up again as a reason for the motion to dismiss, okay, in this motion. Okay, let's go to number 2. Number 2 is inadmissible evidence, and number 3 is lack of sufficient evidence. Now, I'm going to guess that when they're referring to inadmissible evidence, they're referring to evidence that they feel it was not properly gathered or obtained. Now, this is my complete opinion, so I'm going to say allegedly. I'm thinking allegedly that they feel the way some of the evidence was obtained, it was not legally obtained, and that evidence should be considered inadmissible, okay, at trial. Now, what I am thinking that they're referring to allegedly the touch DNA on the sheet. And the reason I feel that they're alleging that that evidence should not be admissible is because there was a lot of conversation about that evidence. How was that evidence obtained? When was it obtained? Who processed it? How was the family tree built? How basically was the touch DNA processed? Who processed it? All of those things have come up in different motions and hearings, and I'm not going to go over it any further, but I'm believing they're referring to inadmissible evidence as possibly the touch DNA and how the family tree specifically was built. I also have a video that's more recent, maybe in the last 2 weeks, and I'm kind of talking about the touch DNA, and I'm relating it to a different case where they use the family tree, the genealogy research to find a killer. Okay, so I kind of compare it to what happened in what's happening now in these Bryan Kohberger motions and hearings. Okay, so you can check that video out. There's a whole playlist, right? So if you enjoy this case and you like to hear about the Idaho 4 case, you can really check out the playlist, and I talk about the genealogy and family tree and building that and how that was used in a different case, and I related to the Idaho 4. Okay, so check that video out. That's probably in the last week or two. So we're going to go next to lack of sufficient evidence. Now, we're going to go way more into detail, but I feel that some of the things that they feel they lack evidence in, it could be one, the way they handled the car, how they changed the car design and style. They had a different year, they had a different model. They never, for the information that's been out to the public, they never actually said they placed him in the car. They said that there was a white Elantra, but they also made major changes to that information. So that could be part of the lack of the sufficient evidence. Okay, another part that they could possibly be referring to allegedly, now this is my opinion again, I believe they have not sufficiently placed Mr. Kohberger in the house physically. Now they can say allegedly his car was around the murder scene or driving around the murder scene, but they actually haven't identified him and placed him in the house, and they can say that that is due to nobody, like an eyewitness, a video, or more of a DNA presence in the house. So they're saying there could be possibly a lack of sufficient evidence for that. I think they also could say a lack of sufficient evidence would be there's no connection to the 4 victims. So allegedly he did not know them. He went to a different school. He was in a different state, even though they were close, and that they haven't been able to really connect him to any of the 4 victims. So sometimes people want to know a story, right? They want to know, well, why? Why did this happen to them? Why would this person that was not known to them unalive all of them? And the motion to dismiss may be referring to a lack of the connection with Bryan Kohberger as the suspect in these 4 victims, that there is no connection. Now, I could probably think of some more different options for this lack of sufficient evidence, but I won't, because we're going to go over a lot tonight, so I'm not going to think of any more. So the last one is prosecutorial misconduct in withholding exculpatory evidence. So this is something that I have been seeing for some time now. I remember going over some of the in one of the motions, there was a response by the defense, and I can remember talking about the grand jury indictment And I kept reading over and over again how the defense was repeatedly saying we had to go and file a motion to get this evidence. They are taking a long time to provide evidence. They're basically making it difficult, kind of creating the problem where it's no way the defense will be prepared for trial October 2nd, 2023, because there's just such a lack of getting the evidence so they could review it, right? So initially I felt, well, there's a lot of victims. The house is large. For a crime scene, there's different areas. There's outside, inside, second floor, third floor. They had the exterior where there was a second floor balcony. They had a ladder outside the house. There was potentially video where they had video surveillance in the neighborhoods. They had the video footage from the police. They had the video from the neighbor across the street. They had the video where Bryan Kohberger is allegedly driving driving around in the car. They had so much evidence that initially I said, well, maybe it's so voluminous because they are having to, interview all of these people, 4 different victims, find out about their lives, talk to their family, talk to their friends. They have hundreds and hundreds of tips, right? So initially, a couple of months ago, that's a lot to filter through, go through, organize, and then provide to someone else in a meaningful way so that they can investigate it. But as time have gone on and the trial is coming up, some of this has to be kind of, I don't want to say speeded up, but if you can expedite it, and when you get the information, share it, because you should be sharing all of that information, especially what's called the exculpatory evidence, because you don't want to be accused of what's happening here, which is prosecutorial misconduct. So let me give you the definition of that, and then I see 2 comments. I'll read those. So prosecutorial misconduct is a prosecutor's improper or illegal act or a failure to act, especially involving an attempt to persuade the jury to wrongly convict a defendant or assess an unjustified punishment. If prosecutorial misconduct results in a mistrial, a later prosecution may be barred under the double jeopardy clause. So I want to just read to you a portion of the 6th Amendment. The 6th Amendment guarantees the rights of criminal defendants, including the right to a public trial without unnecessary delay, the right to a lawyer, the right to an impartial jury, and the right to know who your accusers are and the nature of the charges and evidence against you. So that's a lot packed in there, right? So let's break it down a little bit more. They have a right to a public trial. We already discussed that, right? But not just a right to a public trial, but a right to a public trial without unnecessary delays. So are these delays unnecessary? Why are the delays coming up? If you have the evidence, or if you had the evidence for months, why has the evidence not been provided to the defense? So that's something that would fall under the 6th Amendment, some rights that protect criminal defendants. So let's go to another one. They have a right to the lawyer, right? They have a right to an impartial jury. Remember when I had the video about a week ago and I talked about the leakage? All of these leaks, all of this evidence, this testimony, things that witness would say, things that law enforcement only know, or the killer would only know, it keeps coming out. It keeps leaking out. And that's a major, major problem, because it causes the public, which is the potential jury members, to find out all of this information. And some of this information could turn into testimony, or this testimony or potential evidence may never enter into the trial. So you've kind of made the jury impartial by leaking out all of this information that would only be known by a very small group, the police, maybe some other law enforcement, some investigators, a forensic team, the killer, the witnesses. Like all of this leakage is a really, really bad thing because it could cause the jury to have a view, idea, or even already know what they're going to do. Or they're going to make them guilty or innocent because of all of the information that's been released to the public. And it's also dangerous for a case like that too, because you never want the information to be out to the public, information that only the killer would know because it hurts the investigation. It makes it very hard for investigators to sit down and interrogate potential suspects when all of the information has already been released to the public. It's harder. Okay. They have a right to know who their accusers are. And they have a right to know the nature of the charges that are against them. So that's under the Sixth Amendment. Okay, so keep moving. So we talked about the motion to dismiss. That's going down on Friday. We talked about parts of that. We talked about criminal defendants' rights, right? And we've really kind of laid a foundation for the conversation, right? Now, I have a lot of notes, so I'm going to try to move quickly with these notes. But there's a lot of things that I want to talk about. The last two parts of this video, the first part is going to be, I want to identify and state all of the major case changes, and then we'll talk about what will the prosecutor do. So let me check out these two comments, and then I'll get to that, those two things. So someone said that Bryan Kohberger is innocent, and the person also said, irrelevant comments. So we won't even go over that. Thank you for your comments, though. So let's get back focused. So let's talk about some of the major changes that occurred in the case from the initial onset of the case throughout these months. How many things have changed? And again, this typically does not happen in a case because really it affects how people view the experts, the witnesses, if they're changing their stories. And not just small things. These are major, major changes in the case. And this really, really hurts the case. And again, my concern is what will happen? What will be the end result? Can we find the killer or killers of these four students? The focus is always finding out who did this to them. Why did this happen to them? How could somebody do this to them? Why, right? We need to know, and we need to make sure that we're doing everything the right way, that we're following leads, that we're not focusing and narrowing in on anyone without having the evidence first. We want to make sure that everything has been collected, has been processed, that that crime scene was giving a fair, proper look through, right? We want video, we want pictures, we want to know what happened and how, right? And all of those things will help us figure out what happened, how it happened, what time it happened, and then we can search from that basis for the subject or subjects. Okay, so let's talk about some of the major changes in the case. So the first thing that I listed was the timeline. So initially, the police had set a certain timeline that was about 2 a.m. in the morning. After review, after looking into the evidence, after looking at the cell phone activity, and after figuring out the time that the various roommates returned home. So, for example, Zaina and Ethan, They returned home approximately 1:45 a.m. Kaylee and Maddie returned home approximately 1:56 a.m. So the 2 a.m. time frame initially probably sounded about right. However, once more investigative work was done, they realized that one, Zaina and Ethan, or at least Zaina, ordered food, and the food was delivered approximately 4:05 a.m. And then from reviewing the cell phone activity for Maddie and Kaylee, they knew that the last activity on the phone was approximately 2:52 a.m. So they know that the time of death that they initially put out at 2 a.m. was not accurate. And when you're making major time changes, we know now that whatever activity they thought was happening at 2 a.m., well, we know that that was not right. It was not accurate. And now you have to go back and move the timeline because of the evidence. Now, what is very wise is you take your time, you gather the facts, you put a timeline together. You take all of the considerations, the witnesses, the video, the cell phone data, all of that activity, and then you set up a timeline in addition to considering what was the time of death, right? And there's ways to figure that out. Not just what I've already said, but you can look at the contents of food. You can look at the body temperature. You can look at the process of the body breaking down, deteriorating, rigor mortis, things like that. Now, in this case, it's going to be harder. It's going to be more challenging because medically, all of those types of methods that you can use to help determine the time of death, you can't really use it in this case because the coroner, she made a decision to come to the scene at 1122 King Road about 5 to 5.5 hours after the 911 call at 11:58 a.m. So we have a huge time lapse between the potential time of death and the time that the coroner decided to come to the crime scene. So that impacts the time of death in a big way, in a big negative way. And we want to go into more detail about that. But the timeline was a major change. Another major change, which I've talked about before in a lot of my other videos, is the car. I believe the car description changed about 3 times. It was different models, it was different years. And all in all, this again, when you make declarative statements such as it's a specific model, it's a specific year, and when you change and make those major changes, that's also going to be appearing that you're not doing a good job, that your experts aren't doing a good job. So you don't really want to tie yourself in to such specific details in the beginning. And again, just more investigative time could have helped prevent, again, another mistake. Another major change was when the press conference was had, I think it was about 3 days after the murders. They made a statement that the roommates, they were unharmed, but they did not say that they were witnesses. Well, when we look at the probable cause affidavit, clearly one of the roommates' statements makes her a witness. So again, when we have inconsistent statements from law enforcement, we cannot just trust what you say if your statements are not consistent. And that again, that's a major change from going to say that the roommates, you never said they were witnesses and they were unharmed, to now there are a huge part of the probable cause affidavit, especially when you're writing that potentially one of the roommates saw someone walk past them. That is a huge change, huge change. Let's keep going. let's talk a little bit about that press conference again. Um, it was Captain Roger Lanier. He made a statement that the Latah County coroner did the autopsy. Now, this is totally contradictory because she also made a statement, which is highly unusual for a coroner or medical examiner to do interviews or to do press. But it was contradictory because she said that they contracted out with Spokane to do the autopsy by a pathologist. Remember, she is not a pathologist. She is a nurse and she is an attorney. So she's not a pathologist. So she would not be equipped to do an autopsy. She can observe them, but she would not be performing autopsy. She's not a medical examiner. She's a coroner. So that again is a huge contradictory statement. How do you not know who is doing the autopsy? And this is a major murder case. Again, another major change. This was really a contradictory statement. Let's move on. Well, let's say this too. In the report that was provided by the coroner, she actually mistakenly identified the cause and manner of death. I want to explain to you the difference so you understand this is a major mistake. And I'm not sure if it's her lack of experience because she's not a medical examiner, but by her doing this job, this is part of her career for so many years. This is a major, major mistake. Let me give you the information on both so you're aware, you're educated if you don't know. Manner of death. In many legal jurisdictions, the manner of death is a determination typically made by the coroner, medical examiner, police, or similar officials and recorded as a vital statistic. So when a person passes away, their manner of death is going to be recorded, and those details are going to forward to the state that the person lives in because they're keeping records of death for statistical purposes. Now, there's different categories that's used in different jurisdictions, but manner of death determinations include everything from very broad categories like a natural death and a homicide to specific manners like traffic accident or gunshot wound. So that's saying that it can be very specific and identify the actual manner of death. In some cases, an autopsy is performed either due to general legal requirements because the medical cause of death is uncertain upon the request of family members or guardians or because the circumstances of death were suspicious. So they're saying that when they have a death, everyone does not get an autopsy. There has to be a need for the autopsy or a request. For example, if a person dies and they're very, very young and they do not have any type of medical illness, the medical examiner or the pathologist may want to do an autopsy because it is very rare for someone that is healthy to pass away with no known disease. However, if you have a different case, maybe the person that passes away, they're 75 years old, they may have had some type of illnesses, and they were on medication and their death, they're probably not going to receive an autopsy. Now, you sometimes have the family, and the family is concerned about why their loved one passed away, and they may request that an autopsy is done, and the medical examiner can consider that. For example, you may have someone that's fairly young. Let's just give them an age of 45. They don't really have any medical issues, but they may have complained about some issues. And the family is concerned when they suddenly pass away that they're not sure of the why. So they may ask the medical examiner to do an autopsy for more details and also run what's called a toxicology screen. Now, we've talked about the toxicology screen in the past. The toxicology screen is basically going to look at any known substances in the body. For example, medications that you're taking, if there's any drug use, if there's any alcohol, that would all appear on the toxicology screen. Okay. Now, there are 5 manners of death. Natural, that's a natural death. You die from natural causes. An accident, maybe you have a fall at work. Maybe you have some type of injury. Maybe you fall down the steps. Maybe you bump your head, different things like that. Those will be considered accidents. Suicide, you're taking your own life. Maybe that would be through a hanging. Maybe that would be through a firearm or just other means, okay? Then a homicide, that's definite, basically someone taking the life of someone else. That's a homicide. And then undetermined. Sometimes you just don't know why a person passed away. Maybe they're really healthy. Maybe they haven't had any medical illnesses. Maybe they had checkups and haven't seen a doctor. You just don't understand the why, right? So you may have someone that falls in that category of undetermined, or you may even have it left as pending because you're searching. Maybe you have to find their doctor, discuss the details of their death with their doctor, maybe talk to some family members. Maybe there was some issue and the person was not even seeing a doctor, right? But maybe the person was having issues and expressing that to loved ones. So maybe that would be uncovered from talking to family. So things like that, you may have something that is pending that they haven't made a determination, okay, for the manner of death. So now we're going to talk about the next one, which is the cause of death. In law, medicine, and statistics, cause of death is an official determination of the conditions resulting in a human death, which may be recorded on a death certificate. So when you pass away, your cause of death may appear on your death certificate. Okay. So, for example, if a person has diabetes and they feel that that was the cause of their passing, that medical illness may be listed on their death certificate. Any known medical illnesses that contributed to the death will probably be listed, even if multiple ones listed on the death certificate. Okay. A cause of death is determined by a medical examiner. In rare cases, an autopsy needs to be performed by a pathologist. The cause of death is a specific disease or injury. Causes of death can be grouped into 3 categories: communicable, infectious parasites, diseases, and maternal, perinatal, and nutritional conditions, non communicable, or chronic, and then injuries. Now, there are several different reasons why people pass away, but I'm going to give you the top 10 causes of death. The first and the number one is heart disease. The second is cancer. Third is unintentional injuries. Fourth is chronic lower respiratory disease. Fifth is strokes and cerebrovascular diseases. 6 is Alzheimer's disease. 7 is diabetes. 8 is influenza and pneumonia. 9 is kidney disease. And 10 is suicide. Okay. So all of this information can be found on the Hidden Horror page. I know I'm going through it fairly fast, but I want to get back to some of the other things we were talking about so you can review that later, okay? So we talked a lot about some of the major changes in the case. There's a few things I want to highlight. So we'll go over those quickly. Um, so one of the other things that was concerning was the repeated phone calls that were not answered to Jack D. And I would like to know, or something that, I would hope that would come out in the trial through questioning is, was there any emails? Because those calls were back to back for a short time period. And typically, calls back to back would indicate to me that maybe there is an emergency. Maybe one call, two calls, but the multiple calls back to back, even using both Maddie and Kaylee's phone, it really triggered to me that there was an emergency situation happening, and the repeated calls were calls seeking for somebody to answer to help, right? So I was wondering, were there any text messages from the phones to him? Was there a voicemail left or multiple voicemails left? Because I feel like the multiple calls indicated that there was an emergency situation. This is almost 2:45, 3 a.m. in the morning. There are multiple phone calls back to back going to him. So I would like to know, did they obtain those records to see if there were any text messages or voicemails? Because that seemed to be emergency calls. This one here is just something that I was thinking about. A lot of people that may not know, if they have never been on a crime scene or been at a homicide, I know some people feel that you can easily clean up a crime scene, DNA, physical evidence. I can tell you from experience, a lot of people, when there is a homicide, especially the number of homicides here, this is why I'm guessing that the house is going to be destroyed, because of the amount of blood and the horror of the crime scene, being on the second floor and the third floor, and the blood leaking out of the house and down the walls and just everywhere. That's partly why I believe they're going to tear the house down, or they want to tear the house down. But some people feel that you can easily clean up this physical evidence, this DNA, and it's just not the case. A lot of companies exist, and they're paid money to go in as cleaning crews to try to clean up the blood, the matter. I don't want to go into any gross detail, but they hire companies just for this service. It's not easy to do. So when I hear people believing that, if someone uses bleach to clean up blood, that it's not going to be there, they can still test. They can see that there is a chemical in the blood, and they can still test and see that it's blood. They just can identify the DNA, because they've used a bleach or ammonia or something, a strong chemical, to try to clean up the area. But they still can test the area and get a positive test for blood. They just can't identify the DNA. In this instance, this crime scene was probably one of the most difficult for law enforcement. I'm sure many officers that have been on the force for years, decades, would have had a very hard time coming upon this crime scene, especially not knowing that these were homicides. It probably was very, very difficult, very shocking, very sad. They're very young, and to see them with the wounds and defensive wounds, it's extremely sad. And also, I want to say, particularly with the second floor, I don't know if this is true or not, so I'm going to say allegedly. Again, there has not been a trial, so most of the information that I'm gathering and I'm reading and I'm seeing videos about. It has not been presented in court. So again, I'm going to say allegedly to this statement that I'm going to make. When I heard that on the second floor in Zaina's room that Ethan allegedly was against the door, I had to really assess that. When that came out, I had to think, if the two victims, meaning Ethan and Zaina, are in the bedroom and Ethan is against the door. So if you were on the outside of the door, that would make you be standing in the hallway on the outside of the door. How do you open that door? If a person, okay, so Ethan is probably, I would say approximately 175 to maybe 220 pounds. I'm not sure. I do not know him. I'm just looking at his height, his physical build, and I'm estimating what he possibly weighed, right? So this is not accurate. But if I was to say he was about 175 to maybe 220 pounds, that is a lot of weight to open that door and push forward. If you think about things in your mind, if he's on the inside and he's on the door and the door is not able to really be pushed open, how did the killer or killers leave the room? They cannot leave out of the room and then place him up against the door, right? So in my thinking was Ethan and Zaina unalived in the room, and the killer or killers had to exit the room from the inside. Now, common sense, the only way to get out of a room if you're not using the door, because you can't, because his physical body is against the door, it's the window, right? Is it possible? Is it probable that the killer or killers left out of the window in Zaina's room? And if so, was there an acknowledgement by police or law enforcement to search that space? And when I say search that space, I'm referring to the window, the glass, the window sill, if there was woodwork around the window, the walls, was there any handprints, fingerprints? The window had to be lifted up, right? They had to physically climb out of the window and possibly shut the window back. So I would hope that law enforcement is kind of thinking about the processing of the crime scene in a way that is going through scenarios just like I am. I'm not there to see the crime scene. However, I'm assessing the information that is gradually coming out about the crime scene. And again, this is why I said months ago, I do not feel that the house should be torn down at this point. Now, after trial, after the verdict, there is no no future criminal proceedings after that, yes, I would be totally fine with that house being torn down if they want, or making it a memorial site, or wherever the decision is made. But as the case is going on, the prosecution may need to go and revisit that, right? I'm sure that they're protecting it and securing it that no one is going in, and they may have to revisit that to search for additional evidence, because I heard that, and I don't know if it's accurate, but if it is, how would the killer or killers get out of that bedroom? They would have to go out the window, because how would Ethan's body allegedly be against that door? So these are just things that I'm thinking about that I want to make sure that these considerations are being made and thought of, and hopefully that law enforcement is making sure that all of these types of loose ends is has been accurately, completely looked at. Okay, and the prosecutor also. So I just wanted to say that. So the notes there are good. So I can remember, and I'm going to try to wrap this up. I'm trying to speed this up a little bit. This is still talking about the major issue case, changes in the case. I can remember when everything happened and I saw it on the news. I would like for people to let me know if they can recall this, that there was a ladder. So not the rear part of the house, but the side of the house. There was a ladder leaning against the house. I saw it with my own eyes. I'm not sure what happened to that ladder, but I wondered immediately, did they use the ladder? I never really heard anyone talk about the ladder or anything like that. Hopefully, they were diligent and they photographed the ladder and they tried to get fingerprints from the ladder and check for any DNA or blood. But did anybody else see the ladder? It wasn't on the back of the house, the front of the house, but it was on the side where the road was. Um, Let me know. Let me know if you guys saw the ladder and what did you think when you saw the ladder? Okay, so I just wanted to bring that up to make sure that I'm getting all of my thoughts out. Okay, so that's what I wanted to say about the ladder. I know that the prosecutor, she either said or wrote, and I believe she said it, but they said they were not going to use the touch DNA. My question is, or my concern, or my thoughts are going to, was the touch DNA presented in the grand jury indictment? Was that part of evidence that was presented to the grand jury? She can say now that going to trial, she does not want to use that DNA evidence, but was it used in the grand jury indictment? Now, of course, we don't know. We don't know what happened in the grand jury because that was a secret proceeding. However, that was something that I was wondering because if if this is if this is a known sample and this is the suspect sample, why would you not want to use that DNA? Jury know about DNA. They know some of the processes, and that's an important part of the case. And if you feel that that's accurate, that that was collected properly, it was processed properly, Mr. Kohberger was identified properly, that should be evidence that's used. That ties him to the house on the third floor with a knife sheath, and allegedly a knife was used in all four murders. So that is a big part. That is placing Mr. Kohberger at the scene. Now, let me say this. We never know when DNA is placed. We never know when someone touches anything, there's not a date, right? We just know that that's their DNA or that's their fingerprint. However, in this case, because allegedly the sheath was found on the third floor in the bed with the victims, that is very compelling, right? That's something that a jury would want to hear. They would want to see a picture or video. So hopefully the police officer that found that evidence had it on video cam. I want to know, was that captured on video cam? But more importantly, why would that not be presented to a jury? See, the car doing that loop or driving through there allegedly, and they're saying that it matches his car or it's his car, that's only in the area. But the sheath with the touch DNA, that puts him in the house on the third floor with his alleged touch DNA on the knife sheath that was found allegedly in that room, in the same bed with two of the victims. And also, we must not forget there was allegedly a stalker. Allegedly, one of the girls was being stalked. Now, has that been investigated thoroughly? Have police did all they could to try to figure out, was there a stalker? Because from what people that's close to the case say, they say that they were concerned about a stalker, that they were trying to cover, protect, make sure she wasn't alone, that she felt safe. And she believed that she was being stalked. She told it to her friends, she told it to her family. And we cannot dismiss that, particularly because she was unalived in a brutal way. And I remember when law enforcement initially said that this was a targeted attack and a potentially attack that was motivated maybe by emotion or passion. So this kind of goes in line with the idea that if she had a potential stalker, that maybe the stalker is the one that unalived her, and that the other three potentially were not really supposed to be attacked, but it happened. Now it's hard for me to believe that idea, because how do you go into a property that's 3 stories, multiple roommates, multiple vehicles out, and not believe that someone is going to hear, see, or even catch you in this house? I honestly believe that the killer or killers is someone that the victims knew. I really do. The more I think about it, the more I talk about it, the more I investigate it. My concern is, who goes into a house with multiple cars, 3 stories, multiple people could be living there, plus boyfriend staying. And the idea is to take a knife, not a firearm, but a knife to unalive someone. Doesn't make sense to me. It just doesn't make sense to me. Even having only one, killer. I don't know. And even law enforcement, the prosecutor pushing the 7-minute timeline to unalive all the people, and they can't find the alleged murder weapon. They can't find really a lot of DNA evidence, blood. I mean, forensics in this case is really like screaming. Um, it's just sad. It's very sad, and we have to make sure that we're doing everything we can to help law enforcement, help the prosecutor, so that we're getting all of the potential killers, that we're collecting the right evidence, that we're looking at all evidence, all suspects. No one is free. No one is X off the list. They still need to be receiving tips. Okay? So let's keep going. The last thing that I'm going to talk about is, what will the prosecutor do now? What can be done? We are on September the 20th. We are approaching a 1-year anniversary of these 4 beautiful college students being massacred relentlessly, unmercifully. We don't have a lot of answers. We're trying to figure it all out. We're wanting law enforcement to be accountable, to do a thorough, accurate, and complete job so that the prosecutor, so that she can do her job well, because we want to find out who committed these murders. That is the essential goal. So I look to the prosecutor's office. I look to the state of Idaho. I look to law enforcement, federal partners, the FBI. We need answers. We need to know what happened and what are you going to do today? Even if there are some flaws and mistakes, and we know there's major changes in the case. We know this, but we're still praying, hoping that the prosecutor is going to make the right decision. What are you going to do? Are you going to double down on all of these inaccuracies? So many missteps. A lot of people have retired. It hasn't even been 1 year. We don't need people to forget what happened. We don't want them to forget these kids. We don't want this to be an unsolved case, a cold case. We want justice for these young adults and their families, right? Just as it is important to protect Bryan Kohberger's rights, we want to make sure that the evidence that's being presented, that's being collected, that's being examined, is going to fit the killer or killers. It's going to identify them or him or her. Okay? We want to get it right. In this instance, we only have one shot with Bryan Kohberger. So let's keep all involved lifted up in prayer. The families, they have to be going through so much. It's hard. So hard, you guys. You know, I want to keep the right of every criminal defendant at the forefront. And I don't want that to cross hairs with the victims. It has nothing, I don't even like to mention his name because my focus, and it will always be on these four people. Bryan, he's just a person accused, but he has not been convicted yet. He is a presumed innocent until proven guilty. So I'm gonna always push to keep them first, always, and let the evidence lead us, guide us. Let it stand on its own in truth. It shall not change. It should not be changing. You know, I don't want to lose another day, you know, another 6 months, another, you know, year lapping, and we don't know. And their parents don't know. Their families don't know. What happened to them? Why did this happen to them? So I want to thank you for checking out this video. I hope you check out some of my other videos. I have a playlist about the Idaho 4 case, and I would like for you to check it out. I just want to make sure that we're all doing the right thing at every level, whether it's law enforcement, whether it's the prosecutor, whether it's the defense, whether it's the witnesses, the family, the friends, the university. Everybody should be playing a part to figure out what happened to these 4 people. They deserve that. They deserve justice. Thank you for checking out this video, friends. It's really sad. I wanted to come on to just express. Friday is a big day. It's not going to be available to us. It's closed to the public, but it's a big day in this case. And there's a lot of allegations going on. And we won't probably know the result until the judge issues some orders, right? But more importantly, we need to be steps and steps closer to getting some justice for these families. They need that. They deserve that. It will help in their healing, because the way that these students were unalived was horrific. Malicious, unrelenting, devastating, brutality. Okay? So I almost feel like ending in the prayers really wiped me out. I just want to just say, God bless everybody. Bless mankind. Bless the families. And let's remember what we're working for. Let's remember how we're trying to bring justice forward. Bring justice into the light. This crime, this heinous crime happened in the dark. They didn't have the ability to fight back. I do not feel that they were prepared for what happened to them. So let's bring all of this evil into the light and fight against it and bring justice to these kids and to their families. That is all. That's it. Okay? Thanks for checking this video out, friends. Remember to be safe, be smart, be savvy, be well, take care of yourself. And hopefully I will see you in a future video. Bye, friends. Good night.